Okay, welcome candidates. The candidates drew or had a surrogate draw before we started. The first order of business is to introduce yourself. And I believe all of you recognize that you got your rules and the format ahead of time. Good deal. Okay. And so we get 2 minutes for opening statements. We'll have Ms. Maynard goes first, Mr. Rose goes second, Mr. White will conclude the introductory statement. So, Ms. Maynard.
So, good evening. I want to thank Grassroots America. For the opportunity to be here this evening. I want to thank you for coming to learn more about this race. My name is Sarah Maynard, and I'm running for Judge of County Court at Law Number 3. And basically, this is a job interview. So I think there's a couple of things that are important in choosing the right candidate to fill this position. So the first thing is going to be qualifications. I have been in private practice in Tyler for the last 25 years. I owned my own law firm for 22 years, and then 3 years ago when Jacob Putman was elected as our district attorney, I went to work for him as one of the prosecutors in County Court at Law 3. So this court is the newest court in Smith County. It actually started in 1997, and I've worked in this court for my entire career. I also think it's important to know the values and the decision-making process of the candidate that you select for this position. So I am a proven conservative. I have served the Republican Party in Smith County as a precinct chairman, as an election judge. I've been an officer in the Republican Club. I've been active with Republican women, and I've enjoyed being involved with Grassroots America. I am very proud to have the support of people that I respect in this community, including our state representative, Matt Schaefer. And last week, I earned the endorsement of Texas Right to Life. And so I'm very proud of that. I would appreciate the opportunity to earn your vote, and I'm looking forward to talking about the issues facing County Court at Law 3.
Thank you all very much for coming. My name is Trevor Rose. Let's start with this fact. 69% of what this court handles is criminal law. It's criminal cases, and it's civil-related criminal cases. Criminal-related civil matters. Because of that, the court should have a criminal lawyer on its bench, one that has relevant experience in handling those violent crimes. Why relevant experience? Because just like doctors, lawyers aren't all alike. After all, you wouldn't have a podiatrist handle a brain tumor. You'd go to a brain surgeon for that. So relevant experience means that County Court Law Number 3 needs a lawyer like me as its judge. I understand, I practice daily, and have current knowledge of the kind of criminal law that this court handles. Conversely, experience in areas of law that the court don't handle isn't relevant, won't help move the docket on day one. I'm a current prosecutor with Smith County DA's office. I've been a prosecutor for both the Smith County DA's office and the county attorney's office in Cherokee County. In between those two, I had my own law firm. I focused on indigent criminal defense here in Tyler and also in Cherokee County. I have over 10 years of criminal jury trial experience. I've handled over 4,000 criminal cases, managed over 3,500 misdemeanors, and I have presented over 600 cases to the grand jury. Like the 5 points of my campaign star, I have a 5-point plan, and I promise to 1, render prompt ruling on all motions before the court. 2, treat first-time misdemeanor crimes seriously. 3, demand criminal probation accountability. 4, hold convicted offenders responsible to their victims. And 5, assist our district courts in relieving trial backlog. Thank you for this opportunity. I really appreciate it. Thank you.
Thank you. I'm Clay White. I've been a lawyer for 33 years. I'm a trial lawyer. I'm not a prosecutor, and I'm not. And I don't work at the courthouse for the district attorney's office. I am a trial lawyer, and I've tried 250 cases to jury verdict throughout the state of Texas. I've handled tens of thousands of cases. I have a law office in downtown Tyler where I've been for 30 years. And I've represented citizens and businesses across the state. I do have plenty of experience with Class A and B misdemeanors because I do those on a regular basis, and I have for 30 years. I've tried felony cases. It's been a long time since I did that, but I do. I've also handled family law cases on a fairly regular basis, but I don't get paid as a family law lawyer. I don't get paid as a criminal defense lawyer. That's not how I make my money. So, and you're looking at this particular bench, there's family law cases, there's civil cases, there are criminal cases that are A and B misdemeanor, and there are probate cases. Why no one wants to talk about the civil cases, I'm not sure, but they don't. I've handled thousands of civil cases, and they could be medical malpractice cases, they can be product liability cases. They're all in that court. They're going to be in that court. A judge in this particular situation, you're looking at protecting your liberty. Liberty regarding property disputes and liberty regarding your life experience. 2 years. You can have up to 2 years sentence in this case. So a judge in this court is protecting liberty, and that's what you're going to be doing. And that's why I certainly will be doing that. When I went to one of the meetings, I guess it wasn't too long ago, someone asked me, well, I want to ask you one question. You have a backbone. That's it. You have a backbone. And yes, I do have a backbone. And I look forward to bringing it to bear in this particular court. I'm more than well experienced. I look forward to getting to know you better as we go about this process. Thank you.
Okay, I will take the first question, and we'll go in this order. And Mr. Liccardi here is operating the matrix so that we're sure we're random in the order, right? I'm going to make sure everybody knows that they have an equal chance to start first or to end a question, right? Okay, so in this order will be Mr. Rose, then Mr. White, then Ms. Maynard. First question. At one time, there was much discussion in Smith County government about the need to improve the qualification process for indigent defense so that taxpayers were not on the hook for those who can pay for their own defense. Do you believe Smith County courts do a good job of this already? If not, please describe any methods you would employ to enforce personal responsibility where eligibility screening is concerned.
You know, it's hard to say. I have been in this position as an indigent defense lawyer here in Smith County. When I applied to be an indigent defense lawyer, it wasn't a whole lot that I had to do to get to that position. I believe I had to have 6 hours of continuing education in criminal law, and that's it. It was handy for those people that didn't have a whole lot of experience. The thing about Smith County is that I think the biggest problem is getting people to apply to be indigent defense lawyers that have a whole lot of experience. And so I think outreach is one of the biggest things that we can do to improve that. And I know some places require jury trial experience, but when it comes to not being able to get people to sign up for the indigent defense wheel, I think we have to look into that and attract people to that position.
I think the bottom line is if you can afford to pay for a defense lawyer, you should pay for your own defense lawyer, and the taxpayer shouldn't be paying for it. Okay? In regard to that, I think if you're going to do a paupers type situation, you've got to be able to present the evidence that you should be able to present, such as what your financial situation is, and if that includes bank account, credit cards, whatever you've got to do, you've got to be able to present that to the judge to basically substantiate whether or not you need a court-appointed attorney. And I mean, the bottom line is those are your tax dollars are being paid. Now, on the other side of it, the issue of whether or not you have criminal defense lawyers, as far as paid or not paid by you know, how they get paid or how we have them, that's one story. But your direct question, they should pay for their own. You should be able to establish that by them producing evidence of what their ability to pay is.
So one of the things that I believe in is separation of powers. And part of that means that it's the job of the legislature, whether it's in Austin or in Washington, D.C., to establish the law, and it's the responsibility of the judge to enforce that law. So the law establishes that if a client is indigent, then they qualify for a court-appointed attorney. So there are several factors that the judge can use in determining indigence. Certainly income is one of those, but the court can also look at things like, do you own your own home? You know, if you own your own home outright, then you might be able to afford an attorney even with a lower level of monthly income. What kind of vehicles the person owns or other property. So I think all of those factors are important for the judge to take into consideration. As far as the attorneys providing that defense, the number is limited. What I've done is established a monthly program where I provide continuing education for attorneys so that there are more attorneys that are qualified to serve in that capacity.
Thank you, Ms. Faber.
In the county court of law. The issue is not necessarily the county court of law. The issue is in the district courts. So when you say there's a backlog, yeah, there's a lot of folks in the jail. There's somewhat of a backlog, but bottom line is the real answer is no.
Gotcha. Okay.
So as far as backlog, I'm glad to be able to tell you that County Court at Law 3 really does not have a significant backlog at this point. Part of that is because when COVID hit in March of 2020 and the world shut down, your County Court 3 did not shut down. We never missed a docket. Let me back that up. We never missed a docket until February when we had the snow that shut the world down for a week. But before that and until that point, and other than that 1 week, your county court at law has been live and in person. There have been maybe a dozen Zoom hearings during that time. So I'm really proud that this court has kept up with its workload, and there really is not a significant backlog at this point. So that's good news.
Mr. Moore?
And I have spoken with Judge Getz fairly recently, and he did confirm that they do not have a backlog in County Court Law Number 3. Like Mr. White said, the main backlog problem is in the district courts. As a prosecutor in the 7th, we have about 130 cases that are just waiting for jury trial. And one of the things that I want to do is try to help those district courts relieve that backlog. In the County Court at Law 3, we have jurisdiction over state jail and third-degree felony cases. And as a felony prosecutor, I feel that I have the experience and the knowledge necessary to take on some of those cases. The County Court at Law can handle those a little faster to help get some people out of the jail faster and thereby, hopefully, save the taxpayers some money.
All right. Sorry. The order of this question will be Ms. Maynard, Mr. Rose, followed by Mr. White. Like a lot of entities that have large numbers of employees, some employees do an outstanding job and some are, let's just say there's a continuum where there's some on the other end of the spectrum that maybe need some encouragement to do better. So in the inside the courtroom, there's a number of probation officers that are in the system in Smith County, the ones I guess that would specifically deal with your court, whoever takes Judge Getz's place. Those probation officers, there's some on at both ends of that spectrum. What would you do as a judge to improve the level of professionalism amongst the staff?
So the probation officers do not work for the judge directly. The only two employees that are directly answerable to the judge are the two court coordinators. So there's one that will handle the family law cases and one that handles the criminal law cases primarily. So those are the only two employees that are directly responsible to the judge. I've talked with the current staff as far as who's willing to stay on, and the good news is I think there will be some continuity there. So, and then the probation department, it'll be up to the judge to work with them certainly to make sure that their employees have the training and the experience that they need. I have a history of providing training that's necessary. I hold a law enforcement training every year in August for law enforcement officers, and am happy to continue to provide education so that the staff is able to do what they need to do.
I believe Ms. Maynard is correct about that the only people that really report to the judge are the court staff. However, there is a liaison that works with the court, usually assigned to the court from probation. It is a probation officer that's assigned to a particular court. And I believe that the Council of Judges has some input into the head of probation, the chief of probation, but working with them to help encourage them and using that court liaison to be able to kind of communicate the things that the court needs, the court wants, will be helpful, I think, in the long run.
Really it starts at the top, the way an organization works, whether or not they work for you or not. If they're in your courtroom, they're going to do what they're supposed to do in the courtroom. So really it starts from the top and how you manage this courtroom, how professional you are, how prepared you are. Every day when you come to the courtroom, you know what you're doing because you've got a docket you've looked at the night before. It's not like you're waking up in the morning and something is happening, okay? So you know who's going to be there, you know what they're doing, you know what they're supposed to be doing. And it's up to you, the judge, to make sure people are doing what they're supposed to do. So if there's a probation officer there who's not doing what they're supposed to do, or they're not doing it as effectively, it's up to me to let them know that, or certainly let their supervisor know that. I've run large law offices. The law office I have right now, I have 10 staff. It's smaller than it has been in years. It's a professional office. It's run professionally. The people know their jobs and know what they're supposed to do, and there's accountability. So if they're not doing their job, they're not going to be there. I mean, that just is the way it's supposed to be. It's my responsibility to make sure the job gets done, not anybody else's.
Okay, Mr. Fabry will have the next question. And we will go in this order, candidates. Mr. White, number 1, Mr. Rose, number 2, and Ms. Maynard will finish up this round.
Mr. White, are you aware of what the annual budget for County Court at Law 3 is?
The annual budget, is my understanding, was in the several $100,000 range because you have to pay for actually probably up to $300,000 or $400,000 to some degree because you're paying for your staff, you're paying for yourself, and you're paying for others. So when we looked at the budget, when we were looking at the county budget before, which was this last year, a lot of these things seem to go through one court at some point in time. But the budget there is in the $300,000 to $400,000 range.
So if you're elected, what actions might you take to make that office more productive and save the taxpayers some money?
Well, like I was talking about earlier, to begin with, you've got to look at the fact that who's in there, who's working, are they being efficient, are we getting things done? Are we needing criminal defense lawyers that are indigent lawyers? What are we doing to be sure our court and our taxpayers are not paying for lawyers they don't need to be paying for? So each of those areas, those are areas where you can work to get some efficiency in, move more cases, get folks out of jail, that sort of thing.
Thank you.
To answer your first question, about $543,000, a little bit more than that, as of fiscal year 2022. As far as making sure that things run efficiently, I believe that we need to have dockets move continuously. We don't need this holding off like some courts have done. I'm a big proponent of in-person court. I like being in court. A lot of what I do these days has been on Zoom, and I'm not a big fan of it. Sometimes it helps. Sometimes it does improve efficiency, but making sure that people come to court, that they do what they have to do, providing that venue for people to come in is important, and I want to make sure that we do that efficiently so that the taxpayers can get what they pay for.
Thank you. Ms. Maynard?
So isn't it interesting that you heard 2 different numbers there? I think that's interesting. So Mr. White and I both served this last year on the Grassroots America Watchdog Committee, and part of our responsibility was to take, I believe, the 55 departments within the county and analyze their budgets. So we had the opportunity to do that. The interesting thing about County Court at Law 3 was what was presented was a very bare bones budget. It didn't include line items like those attorney's fees that we were just talking about. So there are definitely some things that were left out there. I would say it is the responsibility of the judge of this court to serve justice, but we work for the taxpayer. So anything that we can do to be able to save the taxpayer money is important, because I'm one of those taxpayers too, and I want the money to be spent efficiently. This is an essential service of government, and I believe in limited government, so I only want our government to do essential services, but one of those is protecting public safety, serving justice. That's what this court's primary responsibility is.
Thank you all for your desire to serve this court. I'd like to ask you, it's been my observation that most judges and even lawyers have a penchant for certain types of cases, criminal, family, indigency, etc. Tell us a little bit about each of your preferences and why you particularly like certain types of cases.
The order for this will be Mr. Rose, Ms. Maynard, and Mr. White.
I believe, like I mentioned earlier, I have a lot of experience in criminal law. That's something that I know pretty well. I like criminal law, and I like practicing criminal law because it affects all of us. From the guy that steals a loaf of bread from his local Walmart to the guy that goes and hits somebody as a drunk driver. It affects all of us, whether that's in price increases or being victims of the offense. And so I like to be able to practice in the criminal area so that maybe I can help relieve some of that.
So I am board certified in juvenile law, and the reason that that's important is because the juvenile law certification covers both family law and criminal law, and those are the two primary areas that this court is going to handle. It is a court of general jurisdiction, so there are some civil cases. There's a little bit of overflow, contested probate work, but the majority of the work this court does is family and criminal law. That's where I've spent my career for the last 25 years, because I don't think there's anything more important than our families or really these entry-level criminal offenses. So misdemeanor criminal cases, we're mostly talking about first and second DWIs, thefts, including theft by check, and simple assaults. So simple meaning no weapon involved. Those are entry-level kind of criminal offenses. If you can get a hold of somebody before a criminal lifestyle gets a hold of them, it's a much more effective intervention. So that's one of my passions, is working with people while they're young, before those habits take hold, and try to make the little course corrections that can change the trajectory of somebody's life.
I spent the last 33 years defending people who get sued, defending companies who get sued, defending people's liberty, property, and then also life. So, of course, I've, over the last 30 years, have gotten paid. That's how I've gotten paid, as far as doing trial work in the courtroom, doing litigation work. And I've done that throughout throughout Texas, throughout really most of this area for a long time. So civil litigation is what I've done primarily. That's where I've made my money. Throughout this last 30 years, though, I have been involved with plenty of family law and plenty of misdemeanor type criminal cases. But the bottom line is my experience, of course, has been in litigation, in trial work, how you do things, how you run a courtroom, what evidence comes in, the procedure. I like the procedure, I like the evidence, I like the way courts run, and that's what I've been involved in.
Okay, for the next question, Ms. Maynard will go first, Mr. White second, and Mr. Rose third. What issues are involved in deciding whether or not to admit certain evidence in a particular case?
Oh, that's a really broad question. So obviously it has to be relevant. I mean, so there's a book of the rules of evidence that's about like this. There's criminal rules of evidence and then there's civil rules of evidence. So I have 1 minute, right? So,
Ms. Maynard, it's up to the moderator to decide. You all can have 2 minutes each.
all right, thank you. So, yeah, the basic rule is that the evidence has to be relevant. It can't cross any of the procedural objections like hearsay, just like you hear on Perry Mason on TV. And part of the judge's job is to help focus the attorneys on what relevant evidence means. So attorneys tend to take liberties with that wherever they want their evidence to go. So it's the job of the judge to focus them back on what's important, so what's relevant on a criminal case tends to be more narrow because the issues are more narrow. If you're just talking about a shoplifting, then you only need to talk about the shoplifting. Now on the family law side, a lot more comes in because you may be talking about their background, their education, health issues, mental health issues, substance abuse issues. So there tends to be more that meets the standard of relevance in the family law realm than in the criminal case. But the judge is the gatekeeper for that.
There are strict rules of evidence. There are rules as far as who can testify, what they can testify to, what evidence comes in. It's important that the judge knows how to deal with that and does deal with it. What paperwork comes in, what issue comes in is regarding any type of evidence is simply going to be what the rules say, how it's applicable. If you're dealing with a criminal case, what evidence is going to come in is specific to that criminal case. Nothing is worse than letting a skunk in the jury box, as they say, when you let some evidence into something and it ruins the case and just tilts the case immediately and it shouldn't have been in it all. So you're going to have documents that have to be specifically looked at. They've got to be authenticated. You've got to have witnesses that are qualified to testify. You've got expert witnesses under the rules that have to be qualified to testify. And so you're going to have all of those areas. You're going to have to look at every single piece of evidence. Those are why you're sitting up there and you're making decisions on objections. When someone says something, when they talk about something, when they're asked a question, you need to be able to look at it, evaluate it, and make a determination. You need to do it then. So those are areas you need to look at. I think it's something that everything that goes in the court has to go in correctly.
I'm going to go ahead and say goodbye to Brad as well. But as far as issues involved in evidence, they pretty much covered it very well. But like Ms. Maynard said, the criminal area is very narrow, and that's to protect the rights of the accused person. And so it's important that we understand as judge what is supposed to come in, what should come in, what shouldn't come in. And as Mr. White says, we need to make that decision then and there. A lot of civil law has a lot of pre-admitted evidence that hearings before trial handle all of that. Everything is already admitted into evidence before they even get to trial. On the criminal law, on the criminal side, that doesn't happen. It's in the courtroom. It's while you're sitting there on the bench. They're making that offer, and you have to make a decision right then and there. And that comes with experience. Like I've said, I've had 10 years of criminal trial experience, and I think that is why I am a good fit for this position as a criminal court. A lot of what it handles is that criminal law. And so when we're having a trial, we have to make that decision right then and there, and that's very important to the case and very important to the taxpayers who are paying for us to be there, because if something gets overturned down the road because we make a bad decision, that just costs more money for the taxpayers. So it's important that we get it right the first time.
The next question will come from Mrs. Fabry, and you will answer in this order. Mr. White, 1, Mr. Rose, 2, Mrs. Maynard, 3.
what in your mind would be your philosophical approach to sentencing guidelines?
Well, first of all, sentencing guidelines are sentencing guidelines are, they're set by the legislature as far as that is concerned. So whatever the guideline is, I'm going to follow, okay? There are areas where I can defer from that, and I will defer from it. It depends on what the situation is, what the aspect is with the person that's involved, what their prior criminal history is. But if there are guidelines, unfortunately, we have to follow them. You understand in federal court, I know this in the federal court bench, but they've had huge problems with sentencing guidelines that have basically put people in prison for many years, and the judge had no say-so at all about it. So whatever area I'm going to have say-so in, I'll be able to look at it, I'll be fair about it, and I'll be impartial with it. But the rules are the rules. I'm going to follow the rules as they're indicated.
The sentencing guidelines are mandated to us by the legislature. They have said that in a Class B misdemeanor, it's anything up to 6 months, up to $2,000. We have variation within that based on the facts of the case, things like that. Anything for a Class A misdemeanor, that's anything up to a year in jail or up to a $4,000 fine. And so we can vary within that, but the legislature has said that we can't go beyond it. And that, I think that's good for us because it gives us a little leeway to say, well, this case is worth this case might be worth something different. But as far as sentencing guidelines, I like the way the legislature has done it. I like that they give us a range and not, it should be this for X criminal history and X.
So I would say that sentencing guidelines are a good example of that separation of powers issue that I mentioned before. The legislature has established certain parameters, but within those parameters, the judge has discretion to apply the law to the facts of the case in front of them. So the difference between somebody serving, say, a 6 or 9 month probation versus spending 2 years in the county jail, if it's somebody that you know and love and care about, is a big difference. And so you want somebody who's going to have the experience to be able to take the totality of the circumstances into account, to protect the public safety, to work toward the goals of deterrence and rehabilitation, and apply those effectively and efficiently.
All right, this next question will start with Mr. Rose. Second will be Mr. White, and followed with Ms. Maynard. You each have quite a bit of experience trying hundreds or even thousands of cases, criminal and civil. Can you please describe 1 or 2 cases that were particularly difficult and how you managed that process and why it was difficult for you?
Well, when you say this, the first thing that comes to mind for me is a case that is one of the few cases that I've actually lost in the last several years, and it was a sexual assault of a child case. It was a very difficult case and a very well-known defendant. There were a lot of ancillary things to it, but in the end, our focus was protection of that child and trying to see that justice was done. The jury made their decision for not guilty, and based on what I do, I've had to move on from that. But I learned from that as well in that there are various aspects of cases that could interfere even if we don't think they should. So I've tried to keep that in mind when I review cases and prosecute cases.
You know, I've handled thousands of cases. I've tried more cases than anyone's tried in East Texas in many, many years. One of the ones that I tried 3 times over 10 years in Carthage, Texas. It involved the death of 2 people. It was a large products liability case where we had thousands of documents. 100 witnesses, 7 lawyers, 10 different defendants, all in that case. So you had to organize it, you had to run it, you have to deal with it. The first time it was tried in 2006, there was a jury verdict of $35 million, and it was going against a company. The second time it was tried, 2009, there were other experts involved, other things involved. That particular case, the jury said 0, nothing. So look at what you're dealing with juries. You look at the jury system, you look at what's going on with that. I've tried some big cases, that's one of them, and it took a lot of time and a lot of effort for that.
So part of cutting my teeth as a lawyer was during the 22 years I was in private practice, I spent 12 years prosecuting at the Tyler Municipal Court. Those were Class C cases, things like simple assaults, and they were a lot of fun to try because they were simple cases, and we could try 5 or 6 cases in a day. We would just have jury after jury after jury. So I did that week after week for 12 years. So somewhere in the neighborhood of like 700 jury trials. So I got very comfortable with working with the jury. But let me tell you about 2 that come to mind, criminal and family. So criminal, I had an aggravated assault with a deadly weapon. A young man was accused of stabbing his father with a screwdriver, in response to which his father shot him. So that was a complicated case with a lot of mental health issues. The other one that I will never forget was a termination of parental rights, which is kind of the death penalty of family law cases. 16-year-old twins and a baby. We tried that case at Christmas for 10 days and ended up where we needed to be, but it was a very hard-fought battle.
Okay, so question, and you'll get Ms. Maynard, Mr. Rose, Mr. White.
After looking at your websites and your campaign materials and so on and so forth, you all talk about the principles and values that you have and the kind of things that the people in front of you and from the bench expect you to exhibit. As we determine who we would be voting for, from either your personal or your professional life, give me an example of where your personal principles or values were challenged and how you dealt with that situation.
That's a difficult question. So I have been actively pro-life since I was in high school. I've been working for over 20 years with Living Alternatives and Father Heart in the Smith County community. So I believe in life from fertilization till natural death. But I was appointed to represent a child in a case. He had been hurt by his parents when he was about 6 weeks old, and he lost brain function. The parents got some advice that if they would put him on life support, they wouldn't be charged with murder, and so they did, and then they left the area. And for several years, I watched this child grow as nutrition was pushed through his body, as air was forced through his lungs. Ultimately, we had to make a decision to move from palliative care to hospice care, which meant that they eventually removed some of those interventions that the parents had put in place and allowed a natural death to occur. There were 6 of us that stayed with him at the hospice for 3 days during that process until the Lord took him home, and he's at peace. I went and visited his grave a couple of weeks ago, and I hope to never have to do that again.
I knew you were going to ask this since I heard it in the last one, and I've been trying to rack my brain since you said it in the last forum. I was given an opportunity in law school to learn of test questions prior to the test. That was a difficult decision because in law school things are very competitive. But in the end, it was more important to me to maintain my values, my core beliefs that I shouldn't cheat on this test. And so I was, I had to go and speak with the professor. I did not give any names, but I did say there were some people that knew of the test questions prior to the test, and that needed to be dealt with.
In my job in my firm, and over the years, you know, the way I get work typically is people call me, and I get calls from all over the country to handle cases. And typically those cases come in, they're usually general garden variety type cases, right? Never that big a deal. And most of those I take, and I don't have any problem taking them. That's a decision I make, and I make it on a regular basis 3 or 4 times a day. That happens. But I got a call from a person one time, and it dealt with representing an abortion clinic as far as their particular services and how they endangered a person, and for me to represent that clinic. I'm pro-life, have always been pro-life, and that was with an insurance company, and I told them there was no way for me to be able to handle that particular case. I turned down many, many cases that are alcohol-related, drug-related, other related cases, and I do that on a regular basis with my work.
Okay, so the next question, the order will be from Mr. Eisenbach in this order. Mr. White, Ms. Maynard, finishing up Mr. Rose.
I've got, it's kind of a personal question, and similar to Tom's question, Mr. Fabry's question, but tell us how faith, if you wish, if you prefer, how has faith affected your decision-making, your work ethics, your habits in the courtroom?
I know every lawyer in East Texas. I've worked with every lawyer in East Texas, almost. I'm supported by probably most lawyers in East Texas because they know me and I've worked with them for years, okay? I am chairman of the deacons at First Baptist Church. I've been involved in the deacon ministry there for years. I've been a member there for 30 years. Everyone knows, and everyone who knows me knows my spirit, knows my faith in God. You know, the bottom line here is when you hire a judge, in this situation, what is their mindset? I was saved at 16 in Comanche, Texas, in a football locker room. Okay, I've tried to live the best life I could, a Christian life, and guess what? I'm not perfect, and never have been perfect, but I try to do the best that I can. So, you know, the way I deal with people, I deal honestly, and I deal well with people. I've never had any complaint against me. I don't think I have an enemy out here because they know my ethics, they know what I stand for, and one thing your judge has to do, have a Christian mindset. You don't want someone come to me or going to a judge that bottom line is, you know, you don't know what a boy or a girl is, or you don't know when conception is. Okay, we don't want that. You don't want to be fighting about who, you know, what family law issue there is.
So I'm a Christian, and I hope that's the defining characteristic that I have. That's certainly what I strive for. I was raised in a Christian home. I made a personal declaration of faith as a freshman in high school, and have tried to grow and learn in that since that time. Certainly that affects everything that I do, as it should, including habits, how you order your time, your relationships. It's sustained our marriage for the last 33 years because that is our common core, our common faith, our common value. And there are a lot of things that you can disagree about, but if you have a common source and a creator to go back to, then a lot of that noise falls away and we can fall back to first principles and to the God who loves us.
I was born and raised into the Church of Christ. My parents are Christian people. They've been very good about teaching me and helping me to learn about God and about the things that He asks us to be and that we should be. And as far as your question, you ask how our faith has affected our work, our decisions, things like that. What I try to do is whenever I make a decision, whenever I do anything, I try to remember, I try to think about, is this something that is going to reflect properly on His kingdom? Is it going to advance His kingdom? I was a high schooler during the What Would Jesus Do craze. I had a What Would Jesus Do bracelet. But I think that is something that is important, that we reflect His kingdom for those who might not know. That's something that we're all called to do, and I strive to do that.
Okay, the next order will be Mr. Rose, then Mr. White, and we will end with Ms. Maynard. This has to do with what we call the definition of ethics and integrity, is the distance between what you say you believe and what you do about it. So explain a situation where you have fought for a principle. Describe a situation in which you took a controversial position that angered or offended your peers or colleagues, and explained how you handled it.
That's a tough question. I believe that as far as taking a controversial decision, I have always been of the opinion and belief that marriage is between a man and a woman. I have several friends who identify as gay, but I also am a Christian, and I believe that we're called to love people. We're called to hate the sin, not the sinner. And it's important that we back that up and that we support people no matter what their decision is, but also to try to teach them that we're supposed to follow God's law. And that's all I have.
Well, one thing about lawyers, and that you kind of know about, there are situations that come up in cases that maybe be unethical, or you might think they're unethical, or in some cases there are. So if you look at the fact I've probably handled 50,000 cases over the last 30 years, there's been a large number of them that have involved large amounts of money. I mean, bet the company money, $100 million money. And you would be surprised how people have come into me and they'd say, look, you know what? There's a death case right here. I know our trucker just killed this person, but you know what? Our insurance is an issue, but what if we go and spend our money in Las Vegas and we don't use that $500,000 to settle this case, okay? There are people that try to get out of things that they should be taken care of, and they don't. There have been many times where I've had to tell people, look, you're going to follow the rules, you're going to follow the law, you're going to do the right thing. They don't like it all the time, but you have to do that.
So when I was in law school, I interned with the Rutherford Institute in Charlottesville, Virginia. John Whitehead is the chairman of that group, and it's a First Amendment liberty defense group. And they, I think to their credit, were very even-handed in the types of First Amendment cases they take. So if you believe in religious liberty and the free exercise of religion, then that means not just my religion, not just what I'm comfortable with. So we worked on cases where we defended the religious rights of Hare Krishna groups or other groups that are not part of my faith community, because the principle is what was important there. And I believe that my Christian beliefs are strong enough to stand up to that scrutiny and to play on an even playing field. So the job that we did at Rutherford Institute was to make sure that the playing field was even, and then within that context, then you can have a reasonable and valid discussion about your faith. And so that's what we do.
Okay, so we are at the point in your job interview where you each have 2 minutes to either rebut something that someone said that you didn't agree with, you can introduce a new subject, you can expound on a previous question, or you can tell us about something you've done in this community or something you've done in your job that we haven't already covered. How about that? So 2 minutes will be in this order: Maynard, second Rose, last White.
So there are a couple of things in my experience that we haven't talked about that I would like for you to know. One is that part of my public service history is that when the Emergency Services District 2 was approved by the voters in Smith County, I was one of the initial commissioners on that board. I served for 5 years as the secretary of that group. When it was proposed to the voters, it was advertised that it would be a 4-cent tax valuation out of $100. At the first meeting that we held, there was a motion made to set it at 8 cents, which was the maximum. And the argument was, hey, let's go ahead and get some money while we can, and then we'll back off later. Well, I have studied enough government and history and political science to know that government never gives back money. So I fought very hard on that board. I appreciated the help of Joanne Fleming in helping me to set up the policy and procedures manual, the employee handbook, and to try to get that group started with zero-based budgeting. But what I learned was never start a new governmental entity.
That's good. One of the things that I talked about earlier is that I want to help with the district court backlog. And in order to do that, I actually feel like one of the things that I bring that I can benefit the taxpayers of Smith County is it could save taxpayers over $1 million a year, this plan. About $60 a day is what we spend per person on housing, meals, costs, medical costs in the jail. If they're sitting over there in the jail for about a year, if I can get 30 to 60 of those cases per year from any of the district courts in Smith County, I can save the taxpayers $1 million. And that's one of the things that I really want to do. That's one of the deals that I have worked with some of the district judges on. I have talked to them, and they have been open to it. If elected, I want to use my training and trial knowledge to do that because, like we've said, we're taxpayers too. It would be nice to be able to save that money. And one of the things that has been brought up recently is the new courthouse. It's I think a necessary evil. A lot of times I feel unsafe just walking through the courthouse. But if I can save us $1 million, we can use that toward the courthouse. And so that's one of the things that I have wanted to do, that I wanted to kind of expound upon.
All right, what I really want to expound upon is this. I forgot to introduce my wife, Johnette, who's sitting here, and we've been married 38 years. So I'm glad she's here, and I appreciate her being here. When I was young, I worked with handicapped children 2 summers at Texas Lions Camp for crippled handicapped children. I was a counselor. It got me interested in working with the hearing impaired with deaf and handicapped children. I went on to get a bachelor's degree in speech and hearing and master's in deaf education, where I taught hearing impaired kids for a couple of years, and I thought I was going to be a school principal. Well, so in order to do that, I went to teach 5th grade. So I taught 5th grade for 2 years. And like I said, I learned everything I needed to learn in 5th grade, and I did. So I taught, but during that period of time when I was in Houston, I ended up going to a jury duty, and I got interested in the law. I went to law school in Houston. I worked part-time to go to law school. I paid for my law school. My dad was in the service for 27 years. We didn't have money. We didn't have a lot of money. That's what I did. So we paid for my law school. We moved here in 1991. I've been a lawyer since then. I started the Boys and Girls Club of Tyler. I was its first president here. Okay? I was on the school board at Grace Community School for 5 years. School president 1 year. I've been involved in coaching football, coaching baseball, coaching soccer for my three children. I've got one son who's a Green Beret. I've got another son who works for the Defense Intelligence Agency. I've got a daughter who's a physician assistant. All of them have done well. They've worked hard. I have time to be a judge. None of them are married, none of them are dating. I have time to be a judge. So I'm interested in doing it. I'm going to do it, and I appreciate the opportunity to tell you a little bit about myself.
Okay, candidates, so now's the time you close the deal, and you have 1 minute to do that in this order. It's the reverse of the opening statements. Mr. White, then Mr. Rose, and finally Ms. Maynard.
Let me tell you, as I started this particular, the meeting today, there are 1, 2, 3, 4 amendments to the Constitution that deal with the courts. And the judge is the gatekeeper of your liberty. And that means search and seizure, that means probable cause with any warrant. It spells out how you do a warrant right here in the Constitution, every aspect of it. So we have a responsibility to protect your life, to protect your liberty, and protect your property. That's what a judge does. They have to be knowledgeable, they have to be, have a backbone, have to be able to make decisions. Now, look, this court is going to handle 5 different areas of law, not 2, 5. I know all those areas of law. I've worked in all those areas of law, and I'm more than confident, and I look forward to your vote. Ask me any questions afterwards. Happy to do it. Go to my website. I've got a lot of support. I'm going to get a lot more support, and I'm looking for an endorsement from this group. Thank you very much.
First of all, I want to thank everybody for coming tonight. I've really appreciated getting to share who I am with all of you. And Mr. White is correct that we're talking about our liberties, our freedoms, and this court is very important. And one of the critical aspects of this court is that criminal trial law. That is one of the main areas where we can protect people's freedoms, their liberties, and what we do critically affects people's freedom in that aspect. And I believe that I have the training, the knowledge, the experience to handle that the way it's supposed to be handled, the right way the first time. I appreciate everybody coming out tonight, and I appreciate the board. Thank y'all for giving us this opportunity, and thank you for everything that you do for all of us.
So what I'd like to leave you with is that I am a proven conservative. My track record is getting down and dirty in the weeds and getting the work done. So one example of that is when it was time for my kids to start school, and we were looking around for the best school for them, we found a school that we thought was moving in the right direction, but it had some work to do at the upper level. So when our child was 4, we started teaching high school debate because I had 8 years to get a program ready for my son to be able to walk into. And people laughed, but let me tell you, in 8 years, there was a program ready for him to walk into, and then his sister, and then his little sister. We have, between those 3 children, 6 national debate qualifications. In the 20 years that I taught high school debate, we took 20 students to the national debate tournament, which puts us in the top 1/2 of 1%. So I say that not because it's about school, it's about identifying what the need is, getting in there, getting dirty, and getting the work done. I know the work of County Court Law Number 3 because I've spent my career doing it. I know family law because I've worked those cases, and I know criminal law both as a defense attorney and as a prosecutor, and I can get the job done as judge. I would appreciate your vote and your support.
Thank you, candidates. And we appreciate everyone coming. Be sure you come back on Thursday for another round of candidates.